For all his faults, Doug Winning was a legendary solicitor in Rockhampton in central Queensland. Criminal defence was his bag. He usually did his own advocacy rather than briefing counsel, and he was a true character. Personally, I'm glad to have met him. However, faults there were. In the trial that led to this decision, Mr. Winning was perhaps suffering from medical circumstances. The judgment mentions, for instance, that he had ceased taking prescribed medication. The results seem to have been fairly spectacular. The judgment notes 17 occasions in the trial in which Mr. Winning accused the Crown prosecutor of dishonesty, of misleading the court, and of having instructed a witness to be difficult in giving evidence, in circumstances where the judge was forced to intercede on a number of occasions and admonished Mr. Winning for his behaviour in very strong terms. Apparently, these 17 occasions involved the use of 4 profanities. At another point in the trial, Mr. Winning made an objection and the judge ruled against him. Mr. Winning was then heard on the court microphones to say, "So Your Honour is seriously ruling that in a criminal trial he's allowed to do that?" When the conduct came before QCAT, there was essentially no contest about the fact that Mr. Winning's conduct had been improper. It was very different, for instance, to the conduct of the barrister in Lewis and Ogden, where the material which insulted the court was put for a proper purpose to advance the client's interests. At the same time, however, the court carefully observed the fact that professional rules are not designed to punish practitioners. Their intention is to try to provide a mechanism to protect the public and the administration of justice from any further consequences arising from this conduct. The result was that Mr. Winning was allowed to continue in practice, provided that he complied with the directions of his treating medical staff and also accepted mentoring from very senior legal practitioners. Unfortunately, Mr. Winning's story didn't end well. In 2019, he was arrested for drink driving and convicted of official corruption when the court found that, heavily intoxicated, he had tried to bribe the police officer with $300. His practicing certificate was removed from early 2021. From this case, we learn that even robust advocacy can only go so far. A certain amount of courtesy is demanded by the court.